Hey guys, I feel like I'm running on fumes right now because I've been like on a go from early this morning, just going. Okay, all right. Miss, oh my God. Okay, hold on something. Yeah, hold on. Yeah. Okay, my bad. I'm sorry, guys. I had gotten a message. Okay, let's go ahead on and get started. I was saying that I feel like I'm running on fumes. But good evening, everybody. Welcome to Infamous Sylvie's channel. Um, right now, we're going to be covering what happened today at court. I want to give a shout out to Judge Glansfield, assistant attorney. Shout out to him. I was able to record from the room. Remember earlier last Friday, they didn't let me in. They didn't let me record. Oh, okay. Okay. Steph. Steph, guys, check out the what I just sent y'all. Okay, check out what I just sent y'all, Steph. Don't text me either. Don't text me. Cause they love texting me and the thing be going bling, 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 bling. She talking about I don't see anything. Look at your text message. Don't y'all text nothing. I'm sorry guys. I just have to get on them because I'll be on live, right? Next minute all of a sudden I keep hearing something going bling, bling, bling. And they do it when I'm on live. Look, you see what happens when you part of the crew. You get blasted in the public. Okay, but anyway, guys, shout out to Judge Glansfield, assistant attorney, the person that's up there that he gives them information. Shout out to them because y'all, last Friday, I was not allowed to go, because remember I was telling you I was going in up there and where the family is, and I was recording, and I because I have a Rule 22, the camera person has not been coming the last 3 weeks, so I haven't been able to get some visual footage for you, but I wanted to get, the audio part. So I was going up there with the family up there to record the happenings at the courthouse. But I've gotten some pushback, some you know some friction, some tugging, and I didn't get a chance to record last week. But I found out there was some fireworks on Friday that when I was trying to get my stuff all together, trying to record, I missed a lot. So, but there was some stuff that went on. Uh-oh. Uh-oh. Okay. 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 All right, yeah, I got some stuff, some news. Okay, okay, after I end this, I got some news to give to you guys in a minute. Um, but some news in regarding Mr. Kelly stuff. Do you Let me finish this and then I'll do a live for Mr. Kelly. But anyway, so to make a long story short, shout out to George Chidi as well. George Chidi is going to handle, he's going to file a motion in regards to the issues that we're having as reporters with. So I'm part of that. I'm going to be part of the filing for us to not have the trouble that I've been having in getting the footage and stuff like that in the courtroom. So keep our fingers crossed. Things are happening. I thank God. I thank God. Give him the glory. Give him the honor, because now I'll be able to bring you guys the footage. Okay. So great for that. So let me. Who is typing now? Okay. All right. I was about to get on y'all, but it's not y'all that text me. It's somebody else. Okay. Okay. Hold on, y'all. Hold on. Hold on, y'all. Okay. Okay. Sorry, guys. It's people sending me stuff. Do you believe it is 11:30 at night and I'm still working, still trying to get stuff done? But anyway, let me go ahead on and play these recording from today's hearing. And it wasn't much, but what I can tell you, they had two jurors to do voir dire. You know what voir dire is, when they're questioning them and getting information so they can do the jury process of elimination and things like that. Well, they had two jurors, one male and one female. The male juror, well, they both didn't go through. Both of them didn't go through. But the male, the they were really trying to get him to come through. Prosecution as well. This man had said that basically, he felt Fatty Willis. Let me just play some of this stuff for y'all. Okay, let me just play for some of this. And this is Mr. Steele talking about it. This is after the juror did his testimony. I mean, did his interview, testimony, whatever they call it. So I'm going to go ahead and play it for so you guys can hear it for yourself what happened, okay? All right. And also, after this live, I got one more live to do because I have an update from Mr. Kelly, okay? I got update.
Happened more recently, what he said based on the fact of the former president. So based upon that in totality, I believe that this juror violated your order and has a new name bias. It could be towards or against.
So he's basically saying that juror had biases, right? Not only biases, but the juror violated the judge's rule. You know, like he said, for them not to be able to go on social media or on the media to watch what's going on and get information about the YSL case. And the juror did. The juror told that he basically was listening to it, and they asked him what in specific did he watch or whatever. He talked about how the there was chaos in the courtroom. He talked about the passing of the drugs. He talked about the length of the time the jurors selection process has been. So he basically violated the judge's order, and Miss Love was really trying to get him to keep him there, but eventually he was let go. But let me just play some of the argument that Mr. Steele and Mr. Sharp had at the time, okay? I'm not going to play too much of this because it's kind of like boring, but it's just some information so you guys know where they were at today. And they did not take care of, oh, wait, I got to play the part of what they have. Remember they're supposed to be doing the witness list? Oh my God. It's still not up to par. I just wanted to tell you that, okay?
Fine cues as well as subject matter, as well as lawyers, subject matter. There are people who are clearly to me that sat in the witness chair without clearly me have neck tattoos and face tattoos. But based upon that,
He's basically talking about the other bias that the juror had was the neck tattoo, and he made comment about people who has tattoo basically make poor judgment or something like that, and also that there was some other stuff he said that was very negative, and he also said that he basically praised the district attorney Willis because of her move of getting the Trump people, and how she says, I mean, basically that she favors her and thinks she's doing an amazing job and things like that. So it was a lot of bias and straightforward, you know. And then she also said it's obviously that they did something if they've been convicted or something like that. So all in all, he did not, the judge did not keep him on. But we're gonna just hear a little bit of this. I know you can't really hear Mr. Steele too well. That's one of the problem I'm having when we're up in the room, is that they're not talking directly in the mic, so it sounds like an echo. So that's another thing that, you know, I'm sorry, but that's the kind of stuff that I'm getting. So my apologies, but I just want to share this much with you guys, since I want to bring you guys something from today's occurrence, you know, just a little something. Didn't want to seem like I wasted my time going there today.
in totality, I would like to move for cause by the court to consider the court. Yes, Mr. Short, anything else you wish to add to that?
It said, I'll also point out just following up on the neck tattoos, directly reflect several of the defendants and here and tattoos, including my client, Mr. Stillwell. He stated that the prospective juror stated that he makes a judgment on those people initially that they exhibit very poor judgment.
I think he usually biased.
And also,
I wrote down the book.
yes, well, I'll adopt your recollection of bias as well. Also, Your Honor, regarding his statement about he believes that the gentlemen that are charged are here for a reason.
Didn't I just say that?
is incompatible. I know that this is totality of the circumstances. I also know that there's no magic words that the prospective juror could say to alleviate some of these concerns. He says that he believes, he thinks he can put these feelings aside, but reality is he doesn't know, and we have to make that call. He stated that he believes that as we sit here today, that these gentlemen are here for a reason, based on the judgment of someone, namely D.A. Bobby Willis, who he holds in very high regard, and that is completely incompatible with the presumption of innocence. So, and additionally, Your Honor, we don't know, we do know that this gentleman is following the Trump case. He's fined the DA's office for pursuing the Trump case. The Trump case is going to continue concurrently with this case, and that creates the risk of continuous bias and the, I would say, the multiplication of bias against our clients as he continues to cheer on the DA's office in their prosecution of Trump. So, for all those reasons, Your Honor, and also for the fact that he said he has kept up with this case and observed news reports, which again was in violation of your ad nauseum admonitions, I would ask that you consider striking this third.
Anybody else? I would just ask the court to take into consideration the totality of the. I know that. Add something to it, okay? Right. Please don't repeat. Right. The addition. You aren't going to listen to my instructions either. He went on and added. So, didn't add. So, anything else that has not been covered by Mr. Steele or Mr. Sharp thus far? Yes, Your Honor. The totality that I'm asking the court to consider is the totality of what both Mr. Steele and Mr. Sharp. I'm going to do that anyways. As well as the he seemingly passed the hardship test. I'm not going to consider the hardship because he's passed the hardship. I just asked the court to take in all that. Okay, Mr. Harvey?
You're not going to be able to hear Mr. Harvey, y'all. He did not. Let me just move on.
Which directly leads me to the answers of this particular juror. They were always, I will do my best, I will try.
Case law says that juror answers that's acceptable, unless I look at it from the totality of circumstances.
I understand you're going to take into consideration the totality of the circumstances, but there is a thought.
Oh, hold on. Somebody's calling me. Hold on. Sorry, guys. Hold on, sorry.
That I will try, and I will do my best, is not sufficient. Let me refer on to the United States versus catch it is Zeon, KECHEDZIAN, 912 Fed 3rd, 1023, citing the United States versus Gonzalez, and specifically saying, likewise, we reject any argument that juror number 3's final response, I will try to be fair, is an unequivocal statement of impartiality. As we noted in Gonzalez, that's at 214 Fed 3rd at 1113. A response of I'll try is not an unequivocal statement. And they went on to say, I'll try is not unequivocal. We cannot agree, saying if a parent asks a teenager whether he will be back before curfew, that parent is highly unlikely to find I'll try an adequate, satisfactory, or unequivocal response. Those same cases say that any doubts regarding the impartiality of the juror should be resolved against the juror. That's Burton versus Johnson, 948 Fed 2nd, 1150, and Cambron versus the state in Georgia, that doubts resolved regarding any impartiality are to be resolved against the juror. So I've got do my best, I'll try. We've seen more coverage, we've changed our opinions over the course of the time, and therefore I think that we're in a situation in which 1512 133 applies.
Okay, I'm gonna move up a little bit faster
164
to Ms. Love. Hold on.
Based on the law that the court gave to them. He expressed that he believes that this case is much more serious than even that case because he recognizes the magnitude of the responsibility that he has and the impact that his decisions would have on the lives of each of the defendants. The juror number 326 said based on what he knows and what he has been given by the court, he is capable of setting aside any opinions that he has about neck tattoos not reflecting good judgment, any favor or any affinity he may have towards Madam District Attorney Willis, and he would not let that affect his ability to sit and listen to the evidence and the law that the court gives to him. When I attempted to ask him that particular question, I believe one more time, there was an asked and answered objection because he had answered that question a number of times, that he would be able to set aside any opinions that he may have had and decide this case based on the law and the law that the court gives to him and the evidence that he sees and hears in the courtroom. He said that any potential resentment he may have for serving when asked by the defense would not clog his mind. He said the fact that if the trial lasted 8 months or more, that does not change his answer. And Your Honor, I believe in looking to his responses in the questionnaire regarding his feelings towards having served on the jury that he served on, the civil juror, he explained to the court, he underlined the word like, and asking, when the questionnaire asked, what did you like about your prior jury service? He said, I like participating in that legal process. He explained to the court how he views the process, that deliberating with people from different places, different backgrounds, different walks of life, deliberating with people and coming to and rendering a fair and truthful verdict was something that he actually enjoyed and he took very seriously. He has explained how it is that he would go about balancing any career requirements that he has. He was asked a number of times regarding his feelings towards the district attorney and his feelings towards the defendant, and not one time has he said that he has a bias or a leaning that he cannot set aside. And more importantly, Your Honor, when the court did hear the word bias from the juror's mouth, what he said was he considered his feelings, his beliefs that wearing head and neck tattoos reflects poor judgment. It's a bias towards head and neck tattoos. He clearly articulated that he has no leaning one way or the other as it relates to this particular case. I'd like to cite for the court in responding to Mr. Harvey's argument and his citing of United States versus Kazakhstan, 902 at 3rd, 1023. What the court said there is that it is within a trial judge's discretion to disregard a prospective juror's initial responses suggesting bias if that juror later, quote, commits to lay aside those feelings and reach a verdict based on the evidence presented and the court's instructions. That's from the law that Mr. Harvey quoted to the court. Further, Your Honor, our Georgia Supreme Court has said in Corza versus the state, 273 Georgia, 164 at Penn site 166 through 167. It's a 2000 Georgia Supreme Court case, Your Honor. And this is not the level to which any answers given by this potential juror even rose. But in Corza, the Georgia Supreme Court said a prospective juror's doubt as to his or her own impartiality does not demand as a matter of law that he or she be excused for cause, nor is excusal required when a potential juror states that he or she will try, and that is in quotation marks, the try is, to decide the case based upon the court's instruction and the evidence. A conclusion on an issue of juror bias is based on findings of demeanor and credibility, which are peculiarly in the trial court's province. And those findings, of course, as the court knows, are to be given deference. And in Corza, what the court found was that nothing in the juror's responses compelled a finding that she had formed an opinion on Corza's guilt or innocence. And that is what is so critical here. It is not whether or not the juror has a feeling about the tattoos or about head or neck tattoos, but it is whether or not this potential juror has formed an opinion on either of these defendants' guilt or innocence that is so fixed and definite that he would be unable to set the opinion aside, or that he would be unable to decide the case based upon the court's charge and upon the evidence presented in the case. And in Corza, Your Honor, what we had was that Corza asked the juror whether allegations that Corza was a member of a street gang would interfere with her impartiality. And the juror expressed her belief that if she became convinced that he were such a member, it would interfere with her impartiality. When asked whether if the question of self-defense in the trial had nothing to do with alleged gang membership, she would be able to put aside the issue of whether or not Corza was or was not a gang member. She responded that she believed it would affect her, but that she would have to hear all the evidence. When pressed further and asked if she could put aside any issue of gang membership and judge the issue of self-defense impartially, she stated that she was not certain. The state then asked whether she would try to the fullest extent possible to follow the instructions of the court as to the evidence in the law and to put the issue of gang membership out of her mind at the instruction of the court. And the juror responded that she would try. Your Honor, what we have before the court today is a person who expressed with a higher, much higher degree of certainty and specificity his ability to listen to the evidence, put aside any opinion that he may have, and follow the law that the court gives to him. He has been entirely truthful regarding his affinity for Madam D.A. Willis, but made plain that that would not impact his ability to judge this case fairly on the facts and the law as the court gives to him. Additionally, Your Honor, I believe that first, I want to point out that him having seen coverage, Your Honor, of this case does not in itself at all disqualify him.
In my way, Madam, it's very clear with that, just on what he testified to in terms of the sequence. So I'm concerned about that more than anything else.
Your Honor,
Because the alleged instances and that happened go well beyond the admonition that gave him anyway.
and Your Honor, I believe
And
that.
he said I keep up with this, through the media, which is clearly a violation.
Your Honor, I would ask that the court consider that given the juror's expressions to the court, his testimony that he has and would continue to endeavor to follow the law, whatever that law is that the court gives to him. I believe that when he said that the story comes up while he's watching the news, he has had occasion to see particular stories about this case. Not that he went out particularly and tried to find anything about this case. And to the extent that he did see something about this case, Your Honor, I believe that that is an inadvertent pretrial exposure to media coverage of this particular case. It does not mandate that he be excused for cause, where he or she, as the court found in Ramirez versus the State 279, Georgia 569.
She is not giving up, y'all. She's still going on and on about it.
2005 case. A juror's pretrial exposure to media coverage of a crime does not mandate that the juror be excused for cause, whereas here, the juror expresses the ability to set aside anything they have
That's
heard.
one thing, Ramirez and Ramirez. That's different when I give you a court instruction. I'm very clear about that. Much different than Ramirez, okay? Because you all asked about pretrial experience and exposure. That's different than the court giving you an admonition telling you, hey, don't do these certain things.
Yep.
You go ahead and do it otherwise.
And
Yep.
Your Honor, my response to that would be that this juror has in no way gone out and sought. There's nothing in his responses that reflects that he went and
What
sought.
difference does it make? I mean, I told you, you need to, in fact, my instruction says look away from those particular, if you inadvertently happen to hear it, the script I give tells you what to do.
Yes, Your Honor. And with respect to that, I would ask that the court consider the fact that if the juror sitting before Your Honor believed that he in any way were violating the court's admonitions, given all of the answers that he gave to the court previously, he would have reflected as much in his responses to the court. He has been truthful, to an extent greater than just to a very large extent. He has been extremely truthful, and I don't believe that his seeing the coverage that he has expressed to the court, one, it certainly hasn't made any impact on him. He doesn't remember the particulars as they relate to in person. I could state that his recitation about what he heard had more to do with what an attorney did rather than any one of the defendants. And I would ask that the court find that his inadvertent violation does not rise to the level of excusing him for cause under these circumstances, Your Honor. Additional, Judge?
Let's wrap it up. Come on.
Right, thank you. I would ask, if anything, Your Honor, and rather than excuse the juror for cause under these circumstances, I would ask that the court not deny the juror the opportunity of serving because of an inadvertent act on his part as it relates to media coverage regarding this. And I will also point the court to simply one case before I sit down, Your Honor. In the case of, Sadat Musavi versus the state, 313 Georgia Ave, 433 at Penn site 433 through 35. It's a 2011 Court of Appeals case. The juror, in this case, juror number 28, initially indicated she believed that the defendant was guilty in light of the indictment and that he would have to prove his own innocence. But once the prosecutor fully explained to juror number 28 that the indictment contained just allegations, that the state had to prove the allegations beyond a reasonable doubt, and the defendant was under no obligation to prove anything, the juror indicated she was no longer confusing to be fair and impartial between the state and the defendant. In this case, the record reflected she offered her initial opinion, position, and stated her ability to remain fair and impartial after having a better understanding of the allocation of burden of proof in the indictment. And in this case, the court found that the trial court, it is not isolated responses, but the final distillation of a prospective juror's voir dire, which determines whether a juror is qualified to serve. Your Honor, wrapping up with that, I would ask that the court find that the totality of this juror's answers reflect a fair and impartial and unbiased juror who is wholly qualified to serve, who may have inadvertently, through a misstep or misunderstanding, was exposed to some coverage, but that did not follow his case, has repeatedly expressed his ability to set aside any thoughts he may have or opinions or affinities and give both the state and the defendants a fair trial in this case. We would ask that the court find that under a totality of those circumstances, this juror is qualified to serve and should not be struck for cause.
I tell guys, he tried. He said, wrap it up. Hey, good.
Based on the totality of the circumstances, of course, I'll distinguish this in my remarks. I'm not, I think, in terms of hardship, the juror, I don't find the court to have an issue with his hardship at this point in time. The court is just considering on the totality of the circumstances, basically, his responses that he gave. The court is concerned about the violation of the admonition which this court gave all sets of jurors by acknowledging admonition in regards to what they're supposed to do. And one of the things that they're not supposed to do is look at media coverage in regards to this particular trial. And if so, inadvertently to turn away from that.
Mm-hmm.
He seems to have not done that because he quoted a couple of different things that occurred, allegations of these proceedings to include disruption and the issues that have went along with it. And he said he was saying he was interested because of the lengthy process that this had taken so far.
He sure
so
did.
This is more than passing. I think that he was, he well has told on himself in terms of his watching these particular.
He sure did, Judge. He sure did tell on himself.
His opinion of our district attorney, and even more so, his words upon the charging of our former president, and even holding her in higher regard. And then, as Mr. Sharp did mention, I have some concern about continued bias in regards to those particular responses, or that response from that juror in connection with his total examination. And then lastly, in regards to neck and tattoo questions and response, he started out by saying, it's poor choices, but the thing that concerned the court was that he stated that they started out with a bias. So for those reasons, in the totality of the circumstances, the court is going to grant the motion to excuse juror 326 for cause.
Okay, he's been excused.
326, please.
He's been excused, y'all.
Juror 326, thank you for your patience with us. Sir, we're going to go ahead and excuse you at this point in time. And again, we appreciate your patience with us, okay?
Thank you.
All right, thank you, sir. Be well.
All right, the next one is going to be a lady, so I'm gonna just bypass that one. She's going to be taken off too, but her reason for being taken off is because she, she has children, and she had issues with drop-offs and stuff like that. So I'm not going to stay too long with this one.
A few days ago, and Ms. Love as well, that we had investigator White here. How long will his testimony, potential testimony take?
But before she comes, the judge had to ask them about the witness list. So we're gonna hear that, and I'm just gonna end it because I want to give you guys an update for Mr. Kelly on my next live. But I just want to give you this little short update for YSL. Okay. Hopefully we'll get some more stuff, because tomorrow they're gonna have motion, and they're gonna have they had that motion for suppress for Shannon Jackson. So tomorrow, hopefully, I'll get some good stuff for you guys. Okay, but let me go ahead and play the part where they talking about the witness list. Wait till you guys hear this stuff. They still didn't have it together, so I believe Mr. Still motion is going to be heard, and it should be like off the chain soon. Hold on a second. Let me go to the next one. Hold on.
Meeting at 2:30 that I'm required to go to. But before that, let me go ahead and just take care of a little bit of the news area with your permission. We have gotten some materials from our jury clerk, Ms. Von Kelch, in regards to jurors with extenuating circumstances. And these emails I'm going to attach for purposes of our conversation as well as for the record, and to account for these jurors. The first juror is juror number 422. I have three of them, just to clock in and keep them track. Yes, Mr. Yes. I have them as medical in 9-5. 9-5, yes, I think it's some documentation that we needed to have. That was she was supposed to have back surgery on 9/15, and there's a letter from her physician. I'm just going to include that as part of the court's consideration for that juror, but she did include some documentation, and Ms. Von Kelch forwarded that to us. So I'm going to go ahead and include that. We had already excused her. So do I have any further discussion about juror 422? Okay. And I'm happy to say it. Okay. The next person is juror 691.
Let me see.
2023. His doctor indicates he can return to work after October the 30th of 2023, may return to work.
Okay, this boring part. Okay, I was just trying to get to.
Discussion.
I was trying to get to the part where he's talking about.
Okay, the next housekeeping matter I was going to check up on is the witness list.
There it is.
Professional and expert.
There it is, y'all. The ever.
These is the next.
Look, the ever-ending witness list. The ever-ending witness list. Listen to this, y'all. Just listen. Oh my God. Not that. All right, here we go. Sorry about that.
I witnessed this by professional and lay. And I'll entertain conversation at this point in time. Ms. Logan and Ms. Hilton, you had conversations with your brother and sister of the defense to cover that issue.
Your Honor, we provided them copies, so we not yet had an opportunity to get back from anyone. We emailed them a copy as well, and so I'll let either of them speak to the court.
Before you do that, do you have any, like, consistent with the court's directives last time? Let's start out with your lay, with your professional witnesses. Is there anybody here who's deceased or is that you're not able to get any information for?
Yes, Your Honor, there are some deceased individuals, and we highlighted it on both the.
Is that for the professional or for the lay witness list?
On both witness lists, we highlighted any individual.
In what color?
In red, Your Honor.
In red?
Yes, Your Honor.
So they're in red.
They are deceased.
They are deceased.
Yes.
Okay. If they are in green, what does that indicate?
That means they're in custody.
Okay. And if they're in yellow, what does that mean?
Yellow can fall into one of two categories. One category is that they are the custodian of record, and at this point for that company, we do not have a particular name, so we cannot provide a date of birth or any additional information because they will not provide the actual custodian until we actually have a date where that witness will testify.
Gotcha.
Or there's one individual who's in yellow. At this point, the state is still trying to ascertain who his name is, because we have a nickname of Boo, maybe Boots. You know, the case that was a part of.
That's number 39 on which list? Is that the lay witness list?
Yes, Your Honor, and this is an individual that once you do identify his biographical information, we will provide.
Okay. All right. And for the professional witness list, we updated that in its entirety.
We have, except for you go to the bottom of the last page. Our apologies, these are not numbered, but the very last page.
Tell me what cell number, like for example.
469
Okay.
through.
469 starts with John Davis.
Yes, through 479, Your Honor.
Through 479, that ends with a Thomas Wilson.
Yes, these are individuals that we know through our review that we've written their name down, they come from a police report, and we will identify again for everyone once we go back again to figure out which count is a part of. It's just us quickly reviewing reports probably over the course of the months that we've had the case. Seeing those names, so we wanted to make sure that those names were on the report, but we cannot point directly to which count it is. So
when will you have that updated now?
Our hope is as soon as possible. I can't. We should try to do it by Friday.
And remember me with being retired military by hope, right?
Yes.
Okay, so tell me what. No, that's different. Hope's not a strategy.
Yeah,
so we have to. Yeah. So you tell me. Okay, listen. All right. I'll direct that you have no empty spaces by the 2nd of October.
Okay, thank you, that's it.
All right, that was the first thing. What about how is the index, the evidence index, or I'm sorry, not evidence, the discovery index, as well as the drive, going at this point in time?
No,
That's coming along well.
tall gas. That's Monday. Monday's the second.
Transfer all the
Monday.
data from the old drive to the new, faster one. We did get that transferred. I am organizing it in the new drive to transfer to the 8 terabyte drive that Mr. Weinstein sent over today. So he and I were communicating over the weekend, and yesterday when I called and asked him to go ahead and give me the drive so that we can start the transfer. So as soon as the organization is complete, and that I should finish that by tomorrow.
I'll check on it tomorrow. I mean, I was adding is tomorrow's business anyways. I thought that was just gonna go ahead and,
Yep, tall glass it
check
was.
on the update I was updating, the discovery as well as the formatting of the index. How is that coming? So you told me basically the documentation is being transferred to the drive and you're organizing it at this point in time. Is that correct?
Yes, because the index will match the format that it is in on the drive itself.
Okay.
So yes, the data has been transferred from the slow to the faster drive.
Okay.
And we are formatting it.
All right.
And the index is Hilton is.
I will include this as the next court's exhibit in order to update the list at this point in time.
Thank you.
Okay. All right. Any defense counsel wish to be heard on that issue, or I'm going to check on it again tomorrow. This is just update in terms of court's inquiry as to that. So. Yes.
Yeah, we're not going to be able.
Also, just take note that when I originally complained on the 8th of September, I filed an emergency motion to have bring 6 witnesses. As of September 20th, then the state added up to 308 witnesses here. And then today, Your Honor, and I have to go through them. We've been in voir dire. But now there's an additional 49 witnesses. That takes us now up to 736 witnesses. So I know the court said, we'll take it up further, but if you don't mind, I wish I never complained. Why? Things this road.
How many do you have so far? 7, what? The 49 were added today?
730, yes. 736.
You hear that? 49 was added today.
I mean, I'll have further argument, but I know you said.
Yeah, and you said you were going to put a motion together or supplement so that the court would have a roadmap. Because I do need to. Because my concern is still, as I mentioned earlier, is that I want to know, say for example, I'm in a position I need to get excluded. We might be talking to somebody else. So that's why I need to kind of know the universe of what I'm dealing with before I rule upon that. And I'm going to use that to ask them and inquire about some other things.
He's going to rule on it, y'all. Not today, but he's gonna rule on it if he wanted still.
I'm really concerned at this point in time, given the representation Mr. Geary gave me at the beginning of this trial.
You heard that the judge is kind of,
and this discovery just taking on just wrong.
Yeah, the judge is kind of putting his foot down now, y'all. He wants everything. He wants all his T's crossed and all his I's dotted, and he basically said on Friday that, I'm going to quote it a little bit, that looked like the whole case is going to be thrown out. I'm just saying. Okay? Because he just want everything dotted, everything, all things crossed and everything, and he's giving them ample amount of time. Did you just hear him say that basically he was given I guess a promise from the other state prosecutor that everything was up to, up to par on last year in June, that they were ready to go to trial, right? Everything was supposed to be done, the witness list and all that. And up to now, everything has not been as it was said. So he asked Mr. Steele to prepare a motion. Mr. Steele did the motion for the remedies. So we should see what happens. Everything is being put in. Oh, and you heard they still not prepared. I mean, how you gonna have this list and it's still jacked up? Good morning, Miss Rain. The list is still not right. Jeffrey is going to be bonded because this Granville preparing the DA. Yeah, Wally, I agree with you because I'm telling you, Friday, the frustration the judge had Friday. It is crazy good. It is crazy. It's wild. But let me finish playing this part and then I'm going to end this live so I can do the R. Kelly update and then I can take my butt to bed because I want to be at court tomorrow. Okay, I'm going to finish playing this. Got about 2 more minutes and 33 seconds left of this, okay? Oh, I just messed up. Instead of playing, I went on someplace else. Hold on. Oh, never mind. Never mind. Let me go ahead on and end this live. You got Friday stuff. Tall class, remember, did you see my tweet Friday? They wouldn't let me record. I went up there. The young lady was like, you can't record up there. And I was like, why? No, I was running all over. That's why I didn't get it. I'll have no recording from Friday. My apologies. But that's all changed now. Whenever I don't have coverage downstairs, I can go upstairs with my phone now, and record. So it may not be really good, but at least we'll have something so I can bring you guys the information. I'll have something. When does he rule on the motion? I'm not too sure, Sierra. I'm not too sure, but I know it's going to be pretty soon. But he just want to make sure all the T's are crossed and all the I's are dotted. He wants all motions in. He wants he wants them to reply, and then he's going to make his decision based on that. And the judge is not too happy. He's not too happy with how things are being handled as far as the discovery, the witness list, all of that. A lot of stuff is in violation. So he just want to make sure that whatever he does, it does not come back against him. So he wants to make sure everything is done. And that's why I try to tell you guys, to me, I know a lot of people disagree, but this man has a lot to deal with, okay? And you got to remember, he was a prosecutor. He's a prosecuting judge, meaning that he comes from the prosecution side. So most of the time, they usually weigh towards the prosecution side. If it was a defense attorney, it would be weighing towards the defense side. You understand what I'm saying? So I believe he is doing, to me, from my observation, he's trying to be as neutral as possible based from his background, but because we are outside looking in, it looks like he's not doing enough for it. But in the end, I think at the end, I think he's going to do what is right. He's given the prosecution so much leeway, y'all, so much. And they can never come back and say the judge was against them because the judge gave them a lot. They're the one who's not coming with the game, their game, A game. So I believe he will do the right thing. But he has to make sure all his T's are crossed and all his I's are dotted. He knows that there's some violation that has been done in the court as far as the courtroom tactics, as far with the evidence and Brady rule and things like that. And they are in trial. It's not like trial has not started. Officially, trial has started. Once they started doing the jury selection, that's part of the trial. It's not normal for a trial to last, jury selection to last this long. I believe they were buying time. That's why they told the judge that they needed X amount of jurors, like 1,200, 1,800 jurors. You don't need 1,800 jurors if you're only picking picking 12. What do you need that many jurors for? You could have did it with what, 500? Because they're picking 900 from 900 in the Trump's case. My throat's switching. But anyway, I'm about to end this. I got one more live to do. This is an update on Mr. Kelly. My throat is starting to itch. And I don't feel like going down there and get a tangerine, but I might just have to because my throat is itching like crazy. I'm sorry. Okay. I'll see you guys in a minute. This is going to be R. Kelly update for his Chicago appeals. All right. Anybody have any questions of me before I end this live? You know me, I have to keep going, keep rolling, keep on rolling. Any questions, people? And I will be back with updates tomorrow. There's no court on Thursday, no court on Friday, so I get a chance to keep how long so far? Almost a year. No, it's past a year. You mean, you're talking about the actual trial? Yeah, trial started in January 4th, January 4th is when trial started. So it's almost a year, like you said, Queen. Yeah, it's almost a year. I'm gonna do some honey. My throat is itching. I'm telling y'all, it's ridiculous. These allergies. All right. Good night, guys. I'm gonna end. Those who this is the rest. This is it for you for the night, for me, with me. So you have a great, wonderful night. God bless you. And those who's gonna come on with me with the R. Kelly update, stay tuned. Let me get myself set up and I should be back. Good night, everybody. Bye, Talk Glass. Talk Glass, it should be some fireworks tomorrow. I think it's going to be some fireworks. All right. See you later, guys. Good night.